2009, President Obama signed the federal hate crime law. Shortly thereafter, State Senator Russell introduced a bill in the state Senate to remove Oklahoma from obligations under that hate crime law. Can you talk a little bit about the bill and what its implications are, and talk about where you think that the bill is actually going?
And I'm going to start off by giving a little bit of a history on federal hate crimes legislation, state hate crimes legislation. I'm going to give a quick shout out to the ACLU, to Ryan Cox, who's shown up here. The ACLU and Equality Network 10, the state legislature, have mounted an extraordinarily effective lobbying effort against Senate Bill 1965. And for the moment, the bill is dead. There's a long ways to go before session's out at the end of May. I wouldn't be surprised to see it back again, but for the moment, the bill died in a Judiciary Committee meeting on Monday night by not being heard. So we can talk a little about that. First, for some relevant statutes, I saw some folks taking notes whenever Brittany gave some citations. Relevant statutes in Oklahoma, our hate crime statute is 21 OS Section 850. The relevant federal statutes are 18 USC Sections 241, 245, 249, and 42 USC Section 3631. What is a hate crime? A hate crime is essentially a crime that's motivated by animus towards a protected class, and that class defined by a statute. And it recognizes that there is an impact based on a hate crime offense that's unique to other crimes. The first is the actual harm to society. That's the impairing the safety and security of the other individuals of that protected class, not even necessarily the victim. And then, of course, the harm to the victim, recognizing the particular harm of a hate crime is often very different than a crime not motivated by hate. In 1969, the Civil Rights Law, which is embodied in that 18 U.S.C. Section 245, that permits federal prosecution of individuals who willfully injure, intimidate, or interfere with another person on the account of the person's race, color, religion, or national origin, when that person is attempting to participate in one of 6 federally protected activities: attending school, patronizing a public place, applying for employment, acting as a juror, or voting. So for brevity, let's skip forward. President Obama, back in October, signs the Matthew Shepard, James Byrd Jr. Hate Crimes Prevention Act. And that changed the 1969 Act in a few very important ways. First, it expanded hate crimes protection to include crimes based on the victim's actual or perceived gender, sexual orientation, gender identity, or disability. This is the first time that any federal law has protected a transgender individual ever. So the bill, the act in itself, is very historic, but for that reason alone, is groundbreaking. It also dropped, and this is important, it also dropped the requirement that the victim had to be engaged in one of those federally protected activities. So it engaged victims, or protected victims, or potential victims of a protected class all the time, not when they're just doing one of these activities. It provides funding and technical assistance to state, local, and tribal jurisdictions to help them effectively investigate and prosecute hate crimes at the request of local law enforcement. And it's important to note that the congressional authority was premised on the Commerce Clause. That's been challenged several times and been upheld. State laws. Oklahoma state law, like I said, is 21 OS Section 850, and it protects victims who are attacked based on race, color, religion, ancestry, national origin, or disability. 45 states have hate crimes. Only 32 protect victims based on sexual orientation. Oklahoma is not one of them. Only 28 cover gender. Oklahoma is not one of them. Hate crimes against LGBT Americans consist of 15% of all hate crimes, and it's third behind race and religion. And that's why the federal law is such an important stopgap measure, because where the Oklahoma statute falls short in protecting LGBT individuals, we have the Matthew Shepard, James Byrd Hate Crimes Prevention Act, which steps in and bridges that gap and provides those protections to Oklahomans, even though our state legislature hasn't seen fit to do so. There are a couple of critiques to the hate crimes legislation. One is that equal protection already protects against hate crimes. That's wrong, and it's wrong for a couple of reasons. First, equal protection only protects suspect classes with strict scrutiny. Who are the suspect classes? I have law students here. I'm going to Hebrew. religion, race, national origin, gender in it, sexual orientation in it. Review evidence tells us sexual orientation warrants may be rational basis plus, but no strict scrutiny protection. Second, you need a state actor. And there was no state actor, at least not literally a state actor, to those folks who tied Matthew Shepard to the fence and let him die, or decapitated James Byrd by driving down the road with him chained to the back of the truck until he was decapitated. So equal protection does not fill that gap. That's why that critique is baseless. Second, there's this notion that it's somehow an abridgment of speech, or some 1984 George Orwell-esque thought crime. And those who argue that this are clearly off-market, sensationalist political rhetoric, the legislative history and the language clearly demonstrates that the Hate Crimes Act does not criminalize speech. It criminalizes speech plus action. You have to act on that speech. For all students, you should be very familiar with this concept. It's studied assault and torts in criminal law or constitutional law, the fighting words doctrine. It takes more than just words. Words only rise to the level of criminal behavior when they're accompanied by something more. So hate crimes don't infringe on a person's First Amendment right to be a nonviolent, bigoted asshole. They only criminalize violent, bigoted assholes. And if you would like the Supreme Court opinion to that, take a look at Wisconsin v. Mitchell. There's a unanimous decision. The cite on that is 508 U.S. 476, 508 U.S. 476, 1993. So Senate Bill 1965, our first version, it does a few things. One, it attempts to deny access to investigative material to federal authorities investigating or prosecuting someone under 18 U.S.C. Section 245. It's interesting to note that the bill's author obviously authored this legislation in response to the Matthew Shepard James Byrd Jr. Federal Hate Crimes Protection Act, in trying to exclude Oklahoma from participating in anything that might even pretend that we care about a person's sexual orientation in a positive way. But he cites Section 245, which is the old 1969 Federal Hate Crimes legislation. It doesn't even mention sexual orientation or gender. And of course, there's an obvious supremacy clause issue with that, whether states can impede in federal investigations or not. But it also would require that DAs and the AG keep litigation files and investigatory reports confidential under 18 U.S.C. Section 245. So if we were prosecuting someone for a hate crime in Oklahoma under our state law, and the federal government wanted to intervene under this law, we would tell the federal government, no, you can't have access to any of our evidence or any of our investigatory or litigated materials. It would prohibit state employees from assisting in the federal investigation or prosecution under the Federal Hate Crimes Act. The implications of that are clear. It's clear that the state of Oklahoma was trying to divorce itself from participating in any manner whatsoever in a federal investigation on a hate crime in Oklahoma's jurisdiction. It's just ridiculous. So we saw a second version come out, a version that was supposed to be a kinder, gentler version of bigotry. And it says that if law enforcement or a state or the state attorney general object to the release of investigatory or prosecution documents evidence, then the federal government, they can get access to it, but they have to petition a court of competent jurisdiction in the state of Oklahoma. Basically, you get hometown. That's the entire reason that we have federal diversity jurisdiction, is to protect individuals from having a court that's friendly with local lawyers, local prosecutors, local law enforcement, from being able to thwart a legitimate investigation. Well, that's exactly what they tried to do. That language was never adopted, and as I said, I think the bill is dead for the